आई थिंक थोड़ा पीछे करना चाहिए था तो सब लोग आ पाते हैं। थोड़ा सा पीछे कर देते हैं।
बॉक्स पीछे करो। चलो रुको।
Good evening to our esteemed guests, distinguished advocates, and all the attendees. I, Riya Giri, on behalf of Bihar Federation of Women Lawyers, extend a heartfelt welcome to everyone gathered here for the legal workshop. Today, we will also inaugurate live streaming on our YouTube channel. We are honored today to have with us Honorable Mr. Justice Bibek Chaudhari, Patna High Court. May I now request Advocate Shreya to kindly present the souvenir and the magazine. Giving a brief introduction, Honorable Mr. Justice Bibek Chaudhari, after beginning his legal practice at Calcutta High Court in 1989, thereafter joined the West Bengal Judicial Service in 1991 and was elevated as a judge of the Calcutta High Court in October 2018. During his 5-year tenure in Calcutta High Court, he disposed of about 6,000 main cases and a similar number of applications relating to constitution, criminal, civil and other matters, which itself speaks volume of his expertise. We are delighted to have Honorable Justice Mr. Bibek Chaudhari with us, and we eagerly look forward to his valuable insights. It is also my privilege and honor to introduce Senior Advocate Mr. Sanjay Singh. May I now request Advocate Ashi to kindly present the souvenir and magazine to Mr. Singh. Thank you, sir. Mr. Singh is a legal practitioner for over 35 years, and Mr. Singh's extensive experience includes experiences in the Supreme Court of India, various high courts and tribunals. He has represented the union government for nearly 8 years as a standing counsel and has a vast experience of dealing with broad spectrum of legal issues. We are delighted to have you with us, sir, and we look forward to your valuable insights. I now hereby request our honorable guest to inaugurate the live streaming of our YouTube channel. The focus area for today's legal workshop is detailed exploration of suspension of sentence and bail, after which there will be a questionnaire round which will be open to all. Now, to gain from the extensive experience and nuanced insights into the complexities of legal practice from one of the field's most respected voices, I would request Sanjay sir to share his views on today's topic.
मंडे को 1 बजे मैटर फिक्स हो गया.
Hello, Justice Bibek Chaudhari. It's a pleasure and an honor to share the time with you. Hello, your reputation of being a conscientious, benevolent, and a friend of the bar. Hello, I welcome you to Patna High Court. Since being the president of one of the associations, I have not had this opportunity. So I use this opportunity to welcome you to Patna High Court. The office bearer of Bihar Federation of Women Lawyers is a long list. And I must take the name of Srimati Venka Sharma, though she is not here. But she is, to most of us, a mother figure, I suppose. A very senior member of the bar now, perhaps not keeping well. But she has been a source of inspiration for all of us. प्रेसिडेंट श्रीमती पटना सिन्हा जी बहुत ही जुझारू महिला हैं और आप सबको इससे सीखना चाहिए हाउ टू स्टैंड इन द कोर्ट विद हर केस एंड नॉट लेट गो. That is the lesson we should learn from her. Alka Verma ji is here and she is also a Judaru Adivakta, if I may say. But she is for a cause and I know she always is there for a cause and her cause is really laudable. So if I may say so, all the young ones, please do inculcate one cause or pick up one cause for you should stand, you should believe in. My dear younger sister, Sumi Srivastava is here, a very eminent criminal lawyer, and I pray I soon see her on the bench. It would be a plus to the Patna High Court. Anuradha Singh ji is here. She is the treasurer of the federation. I'm sure the safe is safe in her hands. Shama Sinha, she is another young sister of mine who is not here, taking care of her younger one who is giving a board exam. But she somehow has been the backbone of this federation, as I know. Maybe I'm wrong. I'm not getting into the politics of the federation, so to say. Prachi Pallavi is here, and a very young, dynamic girl who is an avid reader and writer, and she keeps bombarding me with her rights that she is writing in the newspapers here and there. Must say, wonderful job that she does. Aditi Hansaria is here. I must introduce you to her. She is a blue blood of Eagle fraternity in the sense that she is the niece of Justice Hansaria, who was judge of the Hon'ble Supreme Court, and a great one at that, I must say. And another very Judaru, Priti, is here today. She is there for a cause and always there for whatever comes across her. She's a yes lady, yes, she doesn't know the word no. All dynamic and versatile lawyers, flag bearers of women's cause and empowerment, and friends of marginalized section of the society. I must say, all ladies of substance. I welcome the members of the chapter, the district chapter of Federation, who may have joined us online, and I welcome you. ऐसी बहुत सारी बातें हम करते रहेंगे आपके लिए, और मुझे कहा गया है कि मैं जो भी बोलूँ उसको जरूर हिंदी में ट्रांसलेट करूँ ताकि आप सबके पास मेरी बात पहुँचे. हालांकि ये बहुत दिक्कत की बात होती है, बहुत तकलीफ की बात होगी. हिंदी कोई हमारी मातृभाषा होते हुए भी कोई ऐसा नहीं है कि हम सब बहुत परिपक्व हैं उस भाषा में. I must say, I'm thankful to the Federation, because for one reason, that they have started such workshops, because I feel such discourses and exchanges are a necessary part of acquiring knowledge and training, especially in our profession. ये हमारे यहाँ होता था. This was in the yesteryears, this was a part that it used to, on a regular basis, used to happen in the associations. But I suppose in the rat race of earning money, everybody has forgotten about it. I am really grateful to the Federation and the members of the Federation who have started this, and I just hope that this picks up, and other young members of the association also start getting into such kind of discourses and exchanges. Because coming to the subject, the first topic, of course, because is a it's about suspension of sentence, bail and suspension of conviction. Because we are talking about the scope and ambit of Section 389 of the Code of Criminal Procedure. now we have a new act in Bharatiya Nagrik Suraksha Sanhita 2023. I was trying to look if section 389 is there in this new act also. So I must say that section 430 of this new act is pari materia 389. Now section 389 provides for suspension of sentence pending the appeal and release of appellant on bail. This is only what 389 says. Section 389 is the only section which provides for suspension of sentence and release of appellant on bail, but does not provide for, or any other provision under the CRPC, provide for suspension of conviction. Now this is a new concept which came into the criminal jurisprudence only very recently in 1995 when the Supreme Court, the Hon'ble Supreme Court, propounded this theory and executed it in our criminal jurisprudence system in the case of Rama Naran versus Ramesh Naran. And it is reported in 1995 through SCC 513. Now to understand as to what is suspension of conviction, we must understand the difference between suspension of sentence and suspension of conviction. This is very important. Now we all know that under the CRPC there are, in a criminal trial before a session court, there are two stages. The first stage is that the trial court first finds a person guilty of some offence and convicts him. That is one part. And then the second part is that after the conviction, the court would hear the accused and thereafter sentence him. So that becomes the second part of the trial or of the judgment. Now this judgment together, the order of conviction and the order of suspension, order of sentencing becomes a part of a judgment which is then challenged before the Honorable High Court under section 374. I mean, don't nod your head so much, Sony, because you are giving me bitter. I mean, you are an expert in criminal law. Why should you be nodding your head? But be that as it is. So, now what happens is that section 235 provides that the trial court shall hear the accused on the question of sentence and then pass sentence on him according to the law. After the court records the conviction, the accused has to be heard on the question of sentence. And after the sentence is awarded, that the judgment becomes complete and can be appealed before the High Court under section 374 of the CRPC. I am reading the exact words of the Honorable Supreme Court in Rama Naran versus Ramesh Naran. Now, because what would this mean? This would mean that a judgment passed by the trial court has two parts. One is the conviction part, where accused is found guilty. And the second is that person is then found, having been found guilty, is sentenced. उनकी सजा उनको मुकर्रर की जाती है कि अब आप गिल्टी हैं, इसलिए आपको हम अब सजा देते हैं, और वो सजा मुकर्रर की जाती है। ये दोनों चीजें मिल करके एक जजमेंट बनती है ट्रायल कोर्ट की, जैसे हम 374 सेक्शन 374 में हम चैलेंज करते हैं हाई कोर्ट में। अब सेक्शन 389 जो है वो कहता है कि हाई कोर्ट जब उसको सुनेगा, हमारी अपील को सुनता है, तो वो कहता है ठीक है, हमारे पास कारण है आपके सेंटेंस को सस्पेंड करने के लिए, और सस्पेंड करता है और उनको बेल ग्रांट करता है। तो फिर कन्विक्शन कैसे सस्पेंड होगा? कन्विक्शन जो है वो सस्पेंड तब होता है जब कुछ ऐसे सेक्शंस हैं, कुछ ऐसे कानून हैं, किसी सेक्शन कानून में कुछ सेक्शंस हैं, जैसे कि रिप्रेजेंटेटिव ऑफ पीपल एक्ट या कंपनीज एक्ट। तो कंपनीज एक्ट में सेक्शन 267 है, वो कहता है कि अगर कोई व्यक्ति कन्विक्टेड है किसी ऑफेंस में तो वो मेंबर ऑफ बोर्ड नहीं हो सकता, बोर्ड ऑफ डायरेक्टर्स का मेंबर नहीं हो सकता है, देयर इज ऑटोमेटिक डिस्क्वालिफिकेशन। लाइकवाइज अगर आप कन्विक्टेड हैं किसी ऑफेंस के लिए तो फिर आप इलेक्शन नहीं लड़ सकते हैं। इसको सुप्रीम कोर्ट कहता है कि ये इररिपेयरेबल है, इसको आप दुरुस्त नहीं कर सकते हैं। उसके लिए कहते हैं कि अगर एक डिस्क्वालिफिकेशन अगर उसको किसी कानून के अंतर्गत हो रहा है, तो देयर इज अ डिस्क्वालिफिकेशन व्हिच द पर्सन रिफ्यूजेस एंटेलिंग, देन द ऑनरेबल हाई कोर्ट इन एन एप्रोप्रिएट केस फॉर रीजंस टू बी रिकॉर्डेड, उसके लिए कारण वो लिख लेंगे और वो करने के बाद उनका सस्पेंशन जो कन्विक्शन का जो सस्पेंशन है वो करेंगे। दैट मीन्स द कन्विक्शन वुड बी सस्पेंडेड। ये लॉन्ग एंड शॉर्ट है जो आपके सब्जेक्ट है। जहाँ तक बेल का सवाल है और सस्पेंशन ऑफ सेंटेंस का सवाल, सस्पेंशन ऑफ सेंटेंस जैसा कि मैं बताया कि 389 खुद ही कहता है कि आप सस्पेंड करेंगे सेंटेंस को और उनको बेल कराते हैं। हम लोग एक बहुत कॉमन आर्गुमेंट करते हैं, देयर इज अ वेरी कॉमन आर्गुमेंट वी मेक बिफोर द कोर्ट दैट ही वाज ऑल अलोंग ऑन बेल, he has not misused the privileges of bail, and therefore he should be given this privilege of suspension of sentence or the bail should be granted to him. Not so. The law says that no, you have to record reasons, and this is not a reason just because that he was on bail all along, you grant him bail. No, now he is an accused who has been convicted. There is a conviction against him. So therefore, the person will have to suffer a big argument before the Honorable High Court. Before the High Court records the reason and says, we find reason in your arguments and we will grant you a bail after suspending your sentence. But this is the long and short of this topic. Now, I don't know if I can stop here and ask the questions or should I go to the second topic? I'm checking. Before I go to the second topic, you see on your invitation card, the earlier one, there is handcuff. I don't think that's a good sign. So I would suggest that whoever has designed it, ask him to. There are many things that can be put in there instead of a handcuff, because handcuff is about keeping people in bounds, and I don't want that. And law is all about freedom, I suppose. So therefore, let's not have that handcuff there. Now coming to the second topic, which I must say is a little controversial, and I was a little taken aback as to how to go about it. It is about implementation of Supreme Court's recommendations on time-bound arguments. Now, this concept, as far as I know and my knowledge goes, has been imported from the American system of jurisprudence or American system of courts. And in India, it is driven by the zeal and enthusiasm for disposal of cases. Today, everybody is geared up for disposal of cases, and therefore, people are talking of short arguments and time-bound arguments, etc. Now, this is not something new. This has been there in discussion since 1984, when in the 99th report of the Law Commission of India, this was discussed. And it weighed the pros and cons of the oral and written arguments in higher courts. And it posed two questions. Now, these two questions are very, very pertinent. It says, will it facilitate disposal of a greater number of cases if oral arguments are restricted to half hour on each side? यहाँ पे एक छोटा सा मैं जोक मारता हूँ। हमारे यहाँ एक बहुत ही प्रतिष्ठित सीनियर एडवोकेट हैं। अभी कुछ एक मुहिम चल रही थी जहाँ पे कहा जा रहा था कि अब हम लोग माइलॉज को माइलॉज नहीं कहेंगे, उन्हें हम सर कहेंगे। तो उन्होंने कहा कि तुम लोगों ने, ये डिस्कशन चल रहा था, तो उन्होंने वो सीनियर वकील साहब जो थे उन्होंने कहा कि तुम लोग मेरे खिलाफ एक षड्यंत्र कर रहे हो। उन लोगों ने कहा कि कैसे? तो उन्होंने कहा कि मेरी सारी प्रैक्टिस ही माय लॉर्ड पे है, तुम लोग उसी को बंद करोगे तो फिर हमारी प्रैक्टिस कैसे चलेगी? Having said that, so half hour on each side would be very difficult because half of us would be saying my lords only. But be that as it may. The second question was posed: will a procedural requirement making it obligatory on counsel to file written briefs cut down oral arguments? Thereby meaning आजकल हम लोग को कहा जाता है written arguments दे दीजिए, हम उसको. Now I could have said a whole lot of things, but I would not take, because since this is a little controversial, so I will not take it on my shoulders, my weak shoulders and small shoulders, if I would say so. So I'll be quoting what was recorded by the Law Commission when it was balancing the pros and cons of the, about the argument, people against it and people for it. Now, there were a whole lot of statements which were made, but then one which really I would like to read it for you all is that of Shri H.M. Sanjay, a very renowned and august, esteemed senior counsel, who has written books on constitution and who is in fact, if I may say, the forefathers of one of the forefathers. We just lost a couple of days back in Arihan Sahab. So I'll just read it. He says, in the court, and it will be selective reading, I'll not read the entire paragraph, it will be selective. He says, in the court for a large number of years, oral arguments took place, judges made their own notes, and written arguments were not permitted. In the last few years, a practice has grown up of dispensing with a statement of the case in most cases, accompanied by a suggestion that notes of argument on either side may be put in. The statement of the case was abrogated. It was said that counsel did not know how to draw such statements, and that with rare exception, the statement of the case was useless. I find it difficult to believe that counsel who are unable to draw a statement of the case, which consists of a concise statement of facts, the grounds for the decision in the court or courts below, and submissions of law or fact to show why the decision is wrong, would be capable of being sacrificed. Then he says, but when the case is argued in court, even for limited periods of time, the argument gets modified, qualified, or enlarged as a result of the question from the bench, or in some cases, objections from the other side. Between a written argument and an oral argument, however brief, there is a vast difference. And not only does this procedure lead to delay both in the conduct of the case, because few judges have the time to read notes, and as they are handed in, and also to delay in the delivery of the judgment. But it also involves grave injustice to the appellants. Secondly, it seems to me that it is an outrage to stop responsible counsel for presenting a relevant Nothing is easier than to tell the counsel that this point has been noted and need not be repeated. Entirely different from the mode of work of our Supreme Court. The judges sit for only 4 days in a week for a fortnight for hearing arguments. For the next fortnight, they do not sit in the court at all. They are provided with research assistance. Judicial conferences are held where all the judges are present, where applications for certiorari and the judgment to be delivered are discussed. Written briefs are filed by big law corporations with immense research facilities, including computerized services available repetition. In my opinion, to secure speedy disposal, reasonably early judgments, and for improving the quality of judgments, the earlier practice should be restored. This is very important. Written should not be allowed. The judges should make their own notes and firmly not courteously prevent the repetition. What is he saying? He is saying that oral arguments are more effective. So a judge is perhaps obliged to take his own notes, understand his own issues, and put it in black and white in his judgment. But if a person is repeating, if a lawyer is repeating himself, then he should be courteously by the court told not to repeat since his point is taken. Now this was Chaudhari Saab's his opinion, which was taken into consideration by the law commission. Though our own Narayan Singh, another esteemed and a very senior august senior counsel in the Supreme Court, he was from Patna, grandfather of one of our sitting judges today, a very, very dignified person. He was of the opinion that reform in this direction is extremely necessary. Though he also did not say that substituted, but he said yes, a reform is necessary. Now what happened when the law commission was seized of this matter? What was their conclusion? They say, having considered all these first, let me read the conclusion. We find that there is considerable opposition to such a proposal from many quarters. There is an understandable feeling that something of the element of directness and immediacy that one finds in oral arguments would be lost if time limits are imposed. It also appears from the replies received that many knowledgeable persons are of the opinion that to cut down the time for oral arguments will lead to serious injustice. Now, what is the recommendation? They say, having considered all these aspects of the problem, we are not inclined to suggest any rigid or mathematically precise time limits for oral arguments. It may be difficult to lay down any hard and fast rule for determining the minimum time for oral arguments in all cases. So the bar council election is just over, so it's all bar. But the law commission, they did not make any recommendation that oral arguments should be tolerated. Now, as regards the written arguments, they have said, I read those two lines also. They say, having regard to all these difficulties, we are not inclined, at least at present, to recommend the introduction of a compulsory requirement to filing written arguments in all cases. Now, having read this, obviously, whatever I have read and whatever I have to communicate, perhaps it will be the feeling of most of us. We are a little reluctant to, as it is, lawyers are very reluctant to take anything new. I mean, when the virtual courts came, you know how we resisted. When the computers came and SEC came up with their online, we all resisted. So we are a little averse to new things happening. So maybe we are not feeling very comfortable with reduction in oral arguments. But let's take it that it is, since now the Supreme Court and our own Chief Justice of India is now thinking about it and he is recommending it that it should be incorporated in our system. I'm sure that come a day that it will be incorporated in our system and we will be told to complete our arguments in half an hour or maybe 15 minutes and get over with it. If that be so, then perhaps I'm digressing from the subject, and I must take it upon myself. Like when I was being introduced, somebody, the person said that I have 35 years of practice behind me, all that. What have I learned in these 35 years? I must share it with you, because everybody says that this is wrong, this should not be accepted, but then what is to be done about it? Now, tomorrow morning, this is incorporated in Patna High Court, and it says that no, you have to cut down on your oral submissions, submit written submissions. हम लोग के साथ बहुत तकलीफ होती है जब हमें एक सिनॉप्सिस लिखने को कहा जाता है। और मैं आपको बताऊं कि सिनॉप्सिस हमारे यहाँ, आप कीजिएगा कुछ शायद वकील साहब और साहब और साहिबा लोग उसको बुरा माने, 10 में से 6 तो हमारे स्टेगो लिखते हैं। उन्हें मालूम है कि डेट कहाँ डालनी है और क्या लिखते हैं, तो हम सिनॉप्सिस भी नहीं लिखते हैं। तो रिटन आर्गुमेंट्स कैसे लिखते हैं, या हमारी जो मेन रिट पिटिशंस हैं या जो बेल पिटिशंस, हम बेल ही बात करते हैं, आजकल बेल का ही जमाना है। तो अगर हम बेल भी लिख रहे हैं तो प्लीडिंग कैसे लिखते हैं, क्या लिखते हैं? तो मैंने आज सोचा कि मैं आज थोड़ा सा डाइग्रेस करूँगा सब्जेक्ट से, और मैं ये नहीं कहता हूँ कि मेरी नॉलेज जो है वो बिल्कुल सही है, हो सकता है मैं गलत हूँ, लेकिन मैंने इसको अपनाया है। और गत 35 सालों में अभी तक तो कोई ये नहीं कह पाया कि मेरी रीडिंग जो है वो गलत थी या सही नहीं थी, या इसको बहुत अच्छे तरीके से ड्राफ्ट होना चाहिए था, या स्पेलिंग में मिस्टेक थी। ठीक है, तो इसलिए मैं समझता हूँ कि शायद मैं उसको परिपक्व कर पाया, इसलिए मैं आप लोगों को कुछ सबसे शेयर करूँगा कि कैसे इसको ड्राफ्ट करें, कैसे अपने आर्गुमेंट्स को आप डिज़ाइन करें कि अगर कल को ये हम पर एक फतवा जारी हो जाए कि आपको आधे घंटे के अंदर अपनी बहस खत्म करनी है तो हम कर सकें, ठीक है ना। इसके लिए बहुत सारी बच्चियाँ बैठी हैं। आई रिक्वेस्ट यू टू प्लीज टेक डाउन। 2-3 चीज़ें जो गलती हम लोग करते हैं उसको मैं बताऊंगा। मैंने अपने लिए 5 शब्दों का चयन किया। तो मेरे पास एक ब्रीफ आता है, मैंने 5 शब्दों का चयन किया है। पहला है कि ब्रीफ। जब मेरे पास एक ब्रीफ आता है तो मैं उसको कलम नहीं उठाता हूँ, मैं उसके पहले पन्ने से लेके और लास्ट पन्ने से सिर्फ पढ़ता हूँ, और सिर्फ पढ़ते और ये देखता हूँ कि इसमें क्या लिखता है। जब एक बार पढ़ लिया, 2 बार पढ़ लिया, तो कुछ समझ में आता है कि केस है क्या। एक गलती जो हम करते हैं कि जो क्लाइंट आया उसने जो किस्सा कहानी सुनाया उसी को हम केस समझ लेते हैं। नहीं, केस आपका वो है जो आपके कागज में काले कलम से लिखा हुआ, काली स्याही से लिखा हुआ आपके सामने है, वो आपका केस है। जो मुवक्किल जो आपको केस बता रहा है वो उसकी कहानी। हम लोग गलती ये करते हैं कि उसी की कहानी सुन के हम समझ जाते हैं कि यही केस है। नहीं, वो नहीं, तो इसलिए पढ़िए। दूसरा शब्द जो है वो है कॉम्प्रीहेंड। अभी भी कलम नहीं उठाना है, समझिए कि वो क्या है, केस क्या है। जब एक बार आप उसको समझ, हमारे गुरु लोग कहते थे या सीनियर्स कहते थे, मालूम है कि दफा 302 क्या है, ठीक है, लेकिन हर 302 के केस में एक बार देयर एक्ट जरूर उठा के देखिए कि 302 क्या है, उसको जरूर पढ़िए। आप लोग कहिए क्या बकवास कर रहे हैं, सीनियर 25 साल में बार बार पढ़ने की क्यों जरूरत है। मैं आपसे वायदा कर सकता हूँ कि हर बार जो आप उसको पढ़ेंगे तो कुछ न कुछ उन्हीं 4 लाइनों में कुछ नया मिलेगा। तो इसलिए कॉम्प्रीहेंड कीजिए। जब कॉम्प्रीहेंड आपने कर लिया तो उसके बाद अब आप आइए और उसको एसिमुलेट कीजिए, ठीक है ना। एसिमुलेट की हिंदी होती है आत्मसात कीजिए, ठीक है। इसका मतलब क्या हुआ कि अब आप लिखना शुरू कीजिए, पढ़ना लीजिए, उसके बाएं साइड में लिखिए फैक्ट्स क्या है, दाहिने साइड में लिखिए कि कानून कौन सा आप अप्लाई करेंगे। कानून जो है देयर एक्ट्स में है, और कानून जो है जो कि हमारे हाई कोर्ट से सुप्रीम कोर्ट ने बताया है वो जरूर लिखिए। जब ये हो जाए उसके बाद आप डिजाइन रीडिंग कैसे करें। हमारे गुरुजनों ने हमें सिखाया कि साहब पहली डेट से शुरू करें, एक लिस्ट ऑफ डेट्स बनाएं, लिस्ट ऑफ डेट्स जो है वो शुरू होती है, और जब आप लिस्ट ऑफ डेट्स बनाएंगे तो सारा केस जो है आपके सामने बिल्कुल क्रिस्टल क्लियर, कहते हैं ना, क्रिस्टल क्लियर, तो क्रिस्टल क्लियर की तरह तो वो क्लियर हो जाएगा आपके सामने। और वो जब डिजाइन हो जाए उसके बाद उसको आपको एक्सप्रेस करना, एक्सप्रेस दो जगह करना, एक तो कागज पे जब आप लिख रहे हैं प्लीडिंग्स, और दूसरा जब आप न्यायाधीश महोदय के सामने खड़े होंगे बोलने के लिए, ठीक है। फरीद अलीगढ़ साहब दो दिन पहले उनका इंतकाल हुआ, उन्होंने कहा है कि इंग्लिश इज अ वेरी इंपॉर्टेंट लैंग्वेज बिकॉज द एंटायर कॉन्स्टिट्यूशनल लॉ इज इन इंग्लिश। हमारे यहाँ एक दूसरी बहस चल रही है, देयर इज अनदर सेक्शन ऑफ लॉयर्स जो ये कहते हैं कि हम हिंदी में क्यों नहीं कर सकते। मैं कहूँगा कि हिंदी में जरूर कीजिए, करना चाहिए आपको, लेकिन क्या हम हिंदी में भी परिपक्व हैं? आप मुझे ये बताइए। हिंदी जो है हम जो बोल रहे हैं वो अमूमन हमारे ड्राइंग रूम की हिंदी होती है, जैसे हम घर में बोलते हैं वैसे हम हिंदी को भी इस्तेमाल करते हैं कोर्ट रूम में, जो कि सही नहीं है, क्योंकि कोर्ट रूम की भाषा जो है तो थोड़ी सी फॉर्मल होती है। जब फॉर्मल भाषा होगी, इंग्लिश हो या हिंदी हो, तो जब फॉर्मल होगी तो उसके अंदर आपको बहुत शब्द इस्तेमाल नहीं करने होंगे। इसलिए मेरा सुझाव ये होगा कि आप हिंदी में बहस करना चाहें चाहे अंग्रेजी में करना चाहें, उस भाषा पर थोड़ा सा काम करिए और उसे परिपक्व कीजिए, उस पर कंट्रोल कीजिए, उसको अपने 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 मेक इट अ पार्ट ऑफ योरसेल्फ, वेदर इट्स इन इंग्लिश और इन हिंदी। तो जब वो बढ़िया हो जाएगा तो आपका एक्सप्रेशन बढ़िया हो जाएगा, तब आप आधे घंटे में एक आर्गुमेंट को खत्म कर पाएंगे, ठीक है। यहाँ पे कोई दिक्कत नहीं है, आगे चलूं। हाँ, दूसरी गलती जो हम लोग करते हैं, जब ड्राफ्ट कर रहे होते हैं तो हम एक फैक्ट को ये समझ लेते हैं कि यही लॉ है और यही एविडेंस है, जो कि बहुत कॉमन गलती करते हैं, और स्पेशली ऑन दी क्रिमिनल साइड हम एक फैक्ट को ही समझ जाते हैं कि यही कानून है और यही एविडेंस है, जबकि होता क्या है, फैक्ट जो है उसको अभी साबित करना है, उसके लिए एविडेंस की जरूरत है, और जो कानून है वो हमको जानना होगा, आपका फैक्ट कानून नहीं हो सकता। तो ये गलती कभी मत कीजिए। एक और बड़ी कॉमन चीज है, वो है एडमिटेड फैक्ट्स। Milords, this is an admitted fact. Now, how do you say this is an admitted fact? So what happens? The moment the judge says that, how do you say this is an admitted fact? You are totally at sea. You don't know. You know? Admitted कब होगा कोई चीज? ठीक है, मैं आपको एक एग्जाम्पल देता हूँ। There is an assumption, ठीक है ना, common to plead that the plaintiff is the legal heir of the deceased. ठीक है, ये मान के हम लोग चलते हैं कि जो प्लेंटिफ है या जो पिटिशनर है वो डिसीज का हेयर है, बट हाउ डू वी शो दैट ही इज कनेक्टेड विद द डिसीज? दैट इज द पार्ट ऑफ द एविडेंस। इसीलिए मैंने कहा कि आपका जो फैक्ट है वो आपका लॉ नहीं है और वो आपका एविडेंस नहीं है, ठीक है। तीसरी चीज जो हम लोग अमूमन आजकल के बच्चे जो करते हैं, मैं जो देख रहा हूँ, आई एम नॉट ब्लेमिंग यू पीपल, जो मैं देख रहा हूँ वो ये है कि व्हाई डू वी नीड टू राइट दिस, इसको क्यों लिखा जाए, इसकी कोई जरूरत नहीं है प्लीडिंग में लिखने, अननेसेसरी हम अपने प्लीड को फर्जी बना रहे हैं, वी आर मेकिंग अ प्लीड फर्जी, इसकी जरूरत नहीं है, वी डोंट नीड दिस। एंड व्हेन वी गो टू द कोर्ट and the Hon'ble judge says, where is this? Out comes your 32 teeth, and you say, I'm sorry, Milords, I need 2 weeks to file a supplementary application. Now, I was just here from Calcutta, I'm told that in Calcutta, unless and until the court allows you, you cannot file a supplementary activity. Am I right? Now, why you can't do it? Because if a fact was available to you on the day you received the brief, then why you did not bring it on records? And if you are not bringing it on records, then you are stopped from bringing it on record at a later date. Now, what is the logic behind it? The logic is that on your petition, the other side has already replied. So once he has replied or she has replied, you cannot start making up your case. So in Calcutta, I mean many of you, but Calcutta, this is very pertinent in Calcutta High Court. They don't allow you to put. Only if that point was not available to you on the day the brief was given to you, then the court will allow you to bring it on record. Otherwise, no. So therefore, you don't know what will be the point which will be needed tomorrow in the. So you please bring it on record. Don't judge for yourself that इसकी क्या जरूरत है. आप नहीं जानते कैसे जरूरत है. Therefore, bring it on record. And most important, my case, I know my case. I know the strong strength and the weakness of my case. Amuman, most of the times we are so enamored by our case, the facts of the case, that we all in our dreams also start thinking, this is my victory. And from the other side, a lawyer comes, small point here and there, and you are gone. Your case goes for a six. So therefore, your standard of preparation should be such that you should be able to perceive, imagine as to what is going to be the case of your opponent. That can happen only, my friends, when you have the knowledge of it. If you know if you have the knowledge of law, if you have the basics if you have mastered the basics, I am sure you'll be able to imagine as to what would be the case of your opponent. Once you know that the opponent is going to come up with this case, so what you do, you plug those holes in your case while drafting. That is also a part of assimilation and comprehension. Okay? So you do that. I'm sure that if you do all these things, I mean, I know you all can forget this very conveniently. शाम को बहुत बढ़िया टेस्ट मैच भी हो रहा था, तो स्पोर्ट बहुत इम्पोर्टेंट है. But be that as it may, अगर आप लोगों को थोड़ा सा भी अगर इसको कॉम्प्लीमेंट कर सकते हैं, तो प्लीज कीजिए. And I'm sure that this test, when it comes to us, of giving a written argument and an argument in 15 minutes, for a bail matter, I'm sure if I am a judge, I will not give you more than 5 seconds. Okay, so because you don't need more than that, So how do you prepare? That is most important. So discussion on implementation of Supreme Court recommendation, let me tell you, my friends, it is going to be a reality very soon. Because people are looking at ways and methods, more than methods, to dispose cases. So, ऐसा नहीं हो कि आप फेल कर गए कोर्ट में और आप बाहर निकल करके अपने वकील को ये कहिए कि मैं तो बिल्कुल सही था, जज फेल कर गया. ठीक है? So these words, I stop to my long speech, and thank you very much for being a very good listener. I hope I have made sense. Thank you very much.
Your words were meaningful and your contribution was invaluable, sir. Thank you for sparing time and sharing your views with us. Now, I humbly request and invite Honorable Mr. Justice Bibek Chaudhari to engage in an in-depth analysis of suspension of suspensions and bail.
the President of the Federation, Office Bearers, respected Senior Advocate Mr. Singh. Practically, after hearing this erudite talk and speech, I am thinking that there is nothing left to be said today, because everything, all the matters have been discussed, and what is necessary for the learned advocates to know. And not only that, we have already discussed disposal of cases. Here you see what is my experience in Patna High Court. We see that a litigant, he has come seeking quashing of an affair. Now that repetion of that application under section 482 of the Code of Criminal Procedure, it is going on for 5 years, 6 years. In the meantime, charge sheet is filed, and ultimately that quashing case so this is where time management is absolutely necessary. I personally feel, and for this reason, many a place I am termed as a rebel. I personally feel that when you are pointing one finger to another, others are pointing at you. You see, after filing of a case, some defects are noticed here by the department. Now, takes 15 days time minimum defect, or to note down the defect. Thereafter it goes to the registrar. Registrar takes 3 months. Thereafter, after 2 years, it goes to the honorable judge. The honorable judge passes an order, and it is most mechanically rectify the defects within 4 weeks or 3 years. And thereafter, after 4 years, again the record comes with the defects. So, who are responsible for this? Litigants, the learned advocates, or the system? And in this system, not only we all are part of this system. The judges are officers of the court, advocates are the officers of the court. So, this is to be looked into, this is to be answered at the earliest, and if it is possible, from this seminar only, you can take a resolution to amend and change the Patna High Court rules in such a manner that this type of quashing petition, this type of urgent application ought to be disposed of within 1 month. Now, let me say about time-bound disposal. I am not on time-bound argument. I am on time-bound disposal. In Satindra Kumar versus CBI, the Honorable Supreme Court said that bail applications have to be disposed of within a period of 2 weeks, except if the provisions mandate otherwise. So, if there is a provision that the bail applications cannot be heard by a statute itself, it is to be disposed of within 2 weeks. Is it our experience that bail applications are disposed of in any court from the court of the learned magistrate to up to the court up to this court within 2 weeks. Anticipatory bail applications are to be disposed of within a period of 6 weeks. This is the law of the land now, under the provision of the Constitution. This is the judgment of the Honorable Supreme Court. So, if this judgment is not taken care of, if this judgment is not adhered, what should we? Election. Where will be a place of judiciary? It is the highest time, it is the best time to consider and ponder over it. This is the time-bound disposal. We have to dispose a summons trial case within 6 months. We require to dispose of a warrant trial case within 1 year, and a case 1 year, and a case under sessions trial case, say within 1 year or within 2 years. But it is not possible because of the fact that other agencies are also responsible for delivery of justice. I want to bring the police authority. If the procedure of service of summons and notices and the witnesses summons, witnesses warrants are not taken away from the hand of the police authority, this will be bound to happen, and there will be no escape. The case will pile up. Now, sir said, considering the fact of pendency, number of pendency, not able to call the number, but before that, the order of dismissal is pronounced by the Honorable Judge. A person spending huge amount of money, expenditure, has gone to the Supreme Court to have to make his grievance so that the matter may be heard. But what is happening? Supreme Court is disposing of the case. We are also disposing of many cases. We are not deciding the case. That is the reason we are in this process. We are in many cases. We are causing injustice. If, in my opinion, these things can be answered changing by amendment of rules here and there, if this can be done, that no writ application will be accepted without service of notice to the other side. So, on the date of filing of the application, that can be taken up for hearing. One may say that if the writ is dismissed before admission, or at the stage of admission, we are imposing a financial burden to the petitioner, upon the petitioner, to send the notices to the respondents. What's the use of it? You should not. But if it is done, then you see, I find in my experience here for few days that out of 10 cases, 7 cases for quashing of FIR were very good, very relevant, but because of filing of the charge sheet, we are not in a position to do anything. I am passing the order giving liberty to file an application under section 482 of the CRPC for quashing the charge sheet. Because we do not have any other opportunity, I think that is my personal. Secondly, how the cases are to be concluded early. This is my experience that a person came before the court with a writ petition saying that his affair was not considered by the police, or in other words, against police inaction. What is his case? Suppose a person made an agreement of development agreement for construction of a house. There was some problem between the developer and the owner of the building. An affair was attempted to be lost and it was not taken. Some order was passed wherefrom it is found that an application was filed before the municipality or Patna Municipal Corporation to regularize the defective construction by taking fine. The writ petition went to that direction, and one after another order is being passed for acceptance of money, regularization of the construction, but the case is for acceptance of it. So these are the things where we can save time. It is the role of the judiciary, it is the role of the learned advocates where time can be saved. Now, with regard to other matters, I fully agree with our honorable, with our learned senior advocate. So I think that I should not deliberate on such points. Now, with regard to sentencing, you see, we have talked about section 389. Practically, in some of the high courts, like Calcutta High Court, as soon as an appeal is filed, since with the logic that the appeal is the continuation of the suit or appeal is the continuation of the lease, the order of conviction and sentence, when appealed against, it cannot be said that he is a convicted person. His position is turning to be an accused. And if he was on bail, he is entitled to be released on bail. Again, I am saying about Satinder Kumar Ankil's case, where all sorts of offences has been categorized as Group A offences, Group B offences, Group C offences, and Group D offences. With regard to Group A and C, bail is the rule and denial is the exception. Here, what I find after joining, that whenever in appeal generally bail is not granted against conviction, And wherever in appeal, bail is prayed for, the honorable judges say, are you ready to hear, are you ready in the appeal? Are you ready so that you can hear the appeal? So when you are ready to hear out the appeal, when you are sufficient, then we shall hear the appeal on a next case. We are not inclined to grant bail. No, that should not be the rule, I think. If we read section 389, it will be found that that should not be the rule. The rule is that in an appeal, if the court takes bail, then the accused, not convicted, accused, is entitled to get bail. Practically, the offences where the punishment is 7 years, up to 7 years. In Calcutta High Court, I am not saying that what Calcutta High Court is doing, that is the correct thing. I am placing the things what the Calcutta High Court does, and it is you to decide whether it is correct or wrong. So in Calcutta High Court, when this judgment has come and we came to know about this judgment, we have changed the pattern of the order, first order to be first. The appellant has filed the appeal, let the appeal be admitted, call for lower court record, issue notices, sentence be suspended. Just 4 lines. Because when a person is convicted under any section, up to 4 years, up to 5 years, up to 7 years, bail is the rule. Now, if the bail is granted, giving him opportunity to appear before the court through his learned counsel on a particular date, otherwise his bail will be cancelled, then it is obvious that he will appear. And on that date, we generally fix the hearing of the appeal. And because of the fact that now these judgments have come, not only this judgment, thereafter many other judgments came on this point. Another judgment, Inder Mohan Goswami, before that 2016, volume 2 SCC, the judgment delivered by Rohington Noriman, where the anticipatory principles governing anticipatory bail application, and it has been delineated in 8 or 9 points. The judgment I had kept it, but I forgot to bring it here. So these are the judgments where the issue is how to get an appeal or revision to be decided at an early date. Here we are lacking. I will request the students and the junior members of the bar to read out Justice Khanna's book, Neither Roses Nor Thorns, where he mentioned that when he was district judge of a particular district now in Pakistan, he implemented 5+ cases, 5 years old cases, 5+ cases into 0. So it was prior to independence. It will be a great teaching for the future judges how it was implemented, and it is to be looked into. Now, let me discuss about the principle of sentencing. With regard to early disposal, I have expressed my mind. With regard to the principles of sentencing, here again there are problems. But you see, the main object of criminal trial is sentencing, how the sentencing is to be passed. And in the process of sentencing, we have number of interplayers. You see that the victim wants that the accused should be adequately punished. The accused is engaged in proving that under certain compelling circumstances, under great provocation or under duress or under some disability or inability, the offence was committed. Then the last players are the judges and the learned advocates. Now, what the Supreme Court has said, that is very important now. Previously or still date, we have adversarial justice delivery system. There is a red colored barrier. On that side, you were there, and on the other side, we are sitting. Now, in adversarial justice delivery system, you can submit on behalf of the accused that minimum punishment should be imposed on certain facts and circumstances. Now, according to my decision, I pass the order of sentence. Here, Supreme Court says that the judges and the other legal professionals are appointed. Legal professionals include you also, in order to reach an agreement over certain incident and punishment. So, the sentence must be consensual sentence. Can it be? What are you saying? That is our sentence. You don't have anything to say about sentence. The judges should be in agreement. I shall give you that reference if you want to argue. Now, another thing is that in India we have a problem that there is no code of sentencing. In America there is sentencing guidelines. In UK there is Coroner's and Sentencing Code, Sentencing Act 1990. But in India there is no guideline. We still depend upon the Bachchan Singh's case, aggravating and mitigating circumstances. Practically, we have not crossed above that point. All the judgments subsequently come on sentencing are saying the same thing in different words. So, Bachchan Singh is the law where the only aggravating and mitigating circumstances are been told. Now, it is the problem in India that there is no sentencing guideline. Section 53 IPC says about sentences, death sentence, imprisonment for life, imprisonment up to descriptions rigorous and simple, and then forfeiture of property, and then fine. Now, what happens? There are certain cases where punishment is prescribed which may extend to, इसके बाद 10 years, 7 years, 5 years, this. Then, which may extend to such and such years imprisonment, but it shall not be not less than a particular period. You will find it in the POCSO Act. Minimum punishment is prescribed. Now, even in certain cases, the Supreme Court has passed the order below minimum prescription. In that case, whether we should consider those judgments as precedents or it will be a mere omission. These are the questions. We did not find the answer. You see, again, the state government and the central government has been able or has been given power under Article 72 and 161 of the Constitution to make laws. CRPC under Section 432 and 433, the state government can make laws. Practically, these laws are created. In Bihar, we can say it is Bihar Criminal Act or something like that for the hooligans and goons, and a 1981 one act was pronounced in Bihar also. So these are the power, and in those cases different sentences are prescribed. So in general law and special law, the sentences are in conflict. Where the sentence is okay, there is section 5. That where there is special law or local law, general law will not prevail, local law will prevail. But in respect of the same offence that has been described in the IPC and again in the local law, what will prevail? That is the problem. And this problem practically has not been solved even by the Honorable Supreme Court. I did not find any judgment. Now, I will just say two judgments, facts of the two judgments, where the sentencing policy can be questioned. First, in A. Devendran versus Tamil Nadu, 1997 SCC, A. Devendran versus State of Tamil Nadu, Supreme Court refused and altered the death penalty to life imprisonment, where 3 persons were brutally killed on the ground that primary intention of the accused persons were to commit dacoity and not to commit murder. So, while committing dacoity, if there is 396 murder is committed and it is a murder of 3 persons, we fail to understand why the death penalty will not be awarded. Again, in Vijay Vardhan Rao versus State of Andhra Pradesh, this is a case of 1996. It's a practically bone-chilling case, I should say. Some miscreants practically burned a bus full of passengers. Almost all passengers died and some of them seriously injured. Again, Supreme Court changed the death sentence to imprisonment for life, saying that their main intention was to rob and not to commit murder. At least 23 or 24 people died in that case. So, it is a very peculiar spectacle to consider. You see, while sentencing the judgment, unless and until an agreement is reached, an objective agreement, I should say, is reached, there is a problem because of the fact sentencing always depends on the subjective consideration of a judge. The social status from where the judge has come, the background of the judge, the personal life of the judge, if he has in his family, if he faces a family problem, maybe less than section 498A, he will always take that the wife, the lady, is on the wrong side. So this subjectivity, if sentencing is passed on this subjectivity, I am afraid that proper sentencing can be made or not. Because while granting sentence, the judge should know that in one hand there is victim's cry, on the other hand, though private party is an accused, it is an offence against the society. So there is a public awareness that an offender should be punished properly and just punishment should be given. Again, to quote Shakespeare, justice tempered with mercy. So a judge must be not only impartial, but a passionate person to make a balance between sentences. Now, I told you that only the aggravating and mitigating circumstances, you all know what are the aggravating and mitigating circumstances. I think that though I have stated, I think that I should not refer it. Only thing, for the junior members of the bar, so far as the sentencing is concerned, I have taken note of certain decisions. Will you, if it is helpful for you, you can take it. Year 1981 Supreme Court 1220. Year 1982 Supreme Court 1192. Year 1983 Supreme Court 185. Year 1983 Supreme Court 463. Year 1983 Supreme Court 680. Year 1983 Supreme Court 1155. 1999 SCC Criminal 703. Year 1992 Supreme Court 1595.
Can you repeat the same?
Year 1990 1595. 1995 4 SCC 262. Year 2001 SC Supreme Court 1091. Criminal 344. I have not brought the same practically repetition the recent decisions because of the fact that these decisions are the parent decisions and all subsequent decisions are the follow-up actions of this decision. Now, another thing is that you Bharatiya Nagarik Suraksha Samhita, that it was practically this statute was talked about. Here you will get that suspension of sentence will be made tougher. Suspension of sentences will be made tougher in the Bharatiya Nagarik Suraksha Samhita. Because here the grounds of suspension, if you want, you will have to say merits of the appeal. You will have to submit about the merits of the appeal. But surprisingly enough, in a very recent decision by Justice Patna, Justice Patna delivers a judgment that at the time of suspension of sentence, evidence cannot be looked into. Yes. So if it is that the evidence cannot be looked into, then how I submit about the merit of the appeal? So that remains a question. You will have to say personal circumstances of the convict is to be looked into in Bharatiya Nagarik Suraksha. Then public interest, that is also to be looked into. And the conditions for suspension are the individual may need to provide securities or guarantees for good behavior. They might be subject to restrictions on movement or activities, and financial compensation to the victim or community service could be imposed. So, as a condition, immediately financial compensation is to be paid to the victim before hearing of the appeal, and if the accused is acquitted, then there is no provision how that compensation will be recovered from the victim. So there are things, it is not one day's affair, but I must congratulate you that this is a place we can very well, we can freely and openly talk about the various points on law, and I again am really grateful that you have invited me in this session to say something. Again, I am saying that after Stas' speech, I had nothing to say. I recorded a lot of things, I wrote down a lot of things, but I was compelled to deliver next report because Sir made me to do this. Thank you.
We are grateful to Honorable Justice Chaudhari for insightful views and for sharing his knowledge with us. Now I would like to invite Advocate Ankita to deliver the vote of thanks.
Good evening, honored guests and esteemed colleagues. On behalf of Bihar Federation of Women Lawyers, I, Ankita, extend our heartfelt gratitude to all the distinguished speakers, Honorable Mr. Justice Chaudhari and Senior Advocate Sanjay Singh, for sharing their invaluable expertise and insight at today's legal workshop. Your profound analysis of suspension of sentence and bail, as well as suspension of conviction, has undoubtedly enriched our understanding of this critical legal aspect. Additionally, your discussion on implementing the Supreme Court's recommendation for time-bound agreements underscore the importance of expediting justice delivery. We are immensely grateful for your time, knowledge, and commitment to advancing legal discourse and practice. A special thanks to all the participants for their active engagement and contribution, making this workshop a resounding success. A special accolades to our dedicated volunteer, advocates, Shreya, Priyanka, Ashi, Riya, Neha, Ankita Roy, Smita, Saranda, Aditi, and Soumya. Lastly, our sincere appreciation goes to the organizers, sponsors, and everyone involving in making this event possible. Your support has been instrumental in facilitating this meaningful exchange of ideas and experience. Thank you once again, and we look forward to our future collaboration and endeavors in our collective pursuit of justice and legal excellence.